Well, how does Floyd Abrams measure against Abraham Lincoln? Well, I think two stories help us here. In the first, Floyd Abrams represented Judith Miller, a New York Times reporter who had interviewed Louis Scooter Libby in relation to the public disclosure of Valerie Flame, her identity as a CIA operative. Flame was married to Joseph Wilson, who had traveled to Niger to investigate a Bush administration claim that Saddam Hussein and Iraq had attempted to acquire uranium. Wilson had authored an op-ed piece that stated that the administration knew that the claim was untrue, but pressed it anyway to justify making war in Iraq. Miller was subpoenaed by Special Prosecutor Patrick Fitzgerald to testify before a grand jury investigating the leak and the outing of Flame. Floyd Abrams advanced the claim of reporter's privilege against Miller testifying about her interviews of Libby. In this case, Floyd Abrams was arguing against settled law. And indeed, he was seeking to make new First Amendment law for the protection of the press. While not successful, his constitutional effort demonstrates that Floyd Abrams is indeed a pioneer lawyer, much like our Illinois Prairie lawyer, our son, and railroad lawyer, Abraham Lincoln. In my second example, Floyd Abrams represented Standard & Poor's. Boo. The giant credit ratings agency, which had put its stamp of approval on billions of dollars of debt in the form of hybrid security holdings that failed in the 2008 recession. Many were shocked to see Floyd Abrams appearing to represent what felt to be Wall Street devil itself. Floyd was supposed to be the liberal's dream lawyer, fighting the good fight for the common man and not fighting a fight for stock market industry giants. Here's what Floyd's response to his criticism was. People sometimes have views of what side of issues I should be on that have little to do with reality, he says. I don't spend my life simply working for the ACLU. Floyd Abrams is a lawyer's lawyer. If Mr. Lincoln could look at the decision that we have made, the Abraham Lincoln Association, and the award that we confer tonight, the Lincoln the Lawyer Award, he would be pleased that we recognize Floyd Abrams, an American icon whose career has followed Lincoln's steps. Floyd Abrams' avenue to the public in his career has been the First Amendment. He has practiced and cultivated and spoken extemporaneously on it so that the First Amendment is in his second nature. The Abraham Lincoln Association bestows the 2019 Lincoln the Lawyer Award on Floyd Abrams in recognition of his career in law and the benefit his career has brought the American people. Let's recognize Floyd Abrams.
Thank you so much. This award means more than I can say to me. I do not deceive myself, although I'm very glad to have the linkage of myself and Lincoln. I don't deceive myself about deserving that sort of accolade, but I'm very happy to hear it. It's especially pleasing for me to have just a moment or two just to say what a great advocate Lincoln was and what a model he is for lawyers today and lawyers through our history in terms of his ability to articulate what it is he's talking about. No one else, no one in American history could have written the Gettysburg Address except Abraham Lincoln. Not another president, not a scholar. This was pure Lincoln and I would say only Lincoln. Let me give you just one example of a line, not much commented on, but well known to Lincoln scholars. And I think of it because of all the First Amendment work that I've done. You know, Lincoln suspended the writ of habeas corpus a few times. Southern troops seemed to be getting close to Maryland more than once, and to be really threatening to overcome the Union forces. And Lincoln was very troubled, sometimes angry at what he viewed as Copperhead newspapers in the North, which he criticized, and sometimes went a tad beyond criticism. But how would he phrase it? How would you put it? How would you characterize in sort of one line what it is that you really found outrageous? Here's Lincoln's one line, writing about a soldier who had been convicted of deserting the Union Army and was up for execution. Lincoln wrote, "Must I shoot some poor soldier boy who deserts and not touch a hair of the wily agitator who induces him to do so?" Now, that's a line which would throw shivers into First Amendment types. I mean, that for one thing, it's so good. But beyond that, it hits the weak point of the First Amendment defense that you know, we ought to allow people to have their say, even if it does some harm along the way. But that articulation of Lincoln is a quintessentially Lincoln-esque. So I'm very proud to receive this award. I'm especially proud, I must say, to be here on the podium with my beloved son, who is my favorite traveling companion, and who I am more than lucky and terribly, terribly happy not only to have here, but to have had with me through the years. So thank you, Daniel, and thank you all.
Thank you very much, and congratulations. This is commercial. Want to do that membership thing again? We are very fortunate that we have redesigned our website. We've held off the release of the new version of it until after we got through this dinner and made sure that the old one was still able to take your reservations and let you know about the event. But on February 15th, the end of this week, we turn the switch, and AbrahamLincolnAssociation.org will provide you a modern, and from my perspective, easy to maintain website that will bring you information about Lincoln and also about the Abraham Lincoln Association. So I urge you all to use that. There will be feedback mechanisms in it. You can post, you can send us messages. So use that as a way to let us know what you think we're doing well, what you think we're not doing so well and could be doing better. And we thrive on that feedback. I would like to recognize Rochelle King, who is here. She was the person who designed and worked with us very closely on the website. So thank you, Rochelle. And in the final thank you, there's one special person. We have been very lucky for the past year to have been served by Jessica McPeak. She's our executive manager. She succeeded Mary Shepard a tough act to follow. And Jessica and I have been working together over the past year to get to this stage and to continue to move the ALA forward. So I'd ask Jessica, would you just stand up for a minute? And but we are delighted really to welcome a new person to the field of Lincoln, because he's going to tell us about his first book. He's got a wonderful background which you can read, but things that excite me are obviously a deep respect and understanding of the law, which is so important, but also an appreciation of the miracles of new modern information technology. In addition to his on-air responsibilities, he runs a company that provides information through this new medium called the World Wide Web. I could tell you a lot more, but I'm not going to, because that will use his time, and I will just at this point say thank you very much for joining us, and this is Dan Abrams.
Thank you, Bob. Thank you to all of you. It's really an honor to be here, and I will say that it's a little intimidating for me to be up here talking about Lincoln with all of you. You know, I can talk Lincoln in bar associations and other groups, and know that I can kind of wing it here. I have to say that it makes me a little nervous speaking to the glitterati of the Lincoln bar. And I will also say that James Cornelius, who's here, actually was an advisor on our book, and so it's terrific to be here. But also, as I say, a little bit daunting as I talk about the book and about Lincoln, the lawyer, etc. But let me start with the question I get asked a lot, which is, how did I decide to write this book? I have been an amateur Lincoln aficionado, someone who has always loved history, but it was really my co-author, David Fisher, who came to me and said, there's this transcript out there, and it's the only transcript that exists of any case Lincoln ever argued. And it was only discovered in 1989 in a sort of garage of the great-grandson of the defendant in the trial. And no one's written about it. I said to him, come on. The only transcript that exists of a Lincoln trial discovered in 1989, and no one's writing about it. He said, yeah, I'm telling you, no one's been writing about it. So we dug in, and he was right. There it is, 1989, one New York Times article, one review from the American Bar Association about some of the legal issues involved in this case. And there is this transcript there of Lincoln's own words as a lawyer in a trial. And so we dug in to the case. And I think it's really important when talking about sort of my role in Lincoln scholarship to say that I'm very cognizant of staying in our lane. Many of you know much more about Lincoln than do I. But when it came to this trial, in these 4 days, in late August, early September of 1859, critical point in Lincoln's life, say that, I'm one of the two, maybe with Cornelius, 3 experts in the country on this case. And it also obviously took us into Lincoln the lawyer a bit more. And I'm going to talk a little bit about some of the cases that I think are some of the most interesting to me, that sort of helped shape my view of Lincoln the lawyer. But let me take a step back, and for those of you who haven't read the book, to just talk about what this trial was. This was a case where 2 young men were involved in a kind of ongoing dispute for a few weeks. They were neighbors, they'd been friends, they were telling friends, threatening each other sort of via their friends. One of them, Greek Crafton, was a bigger guy. Peachy Quinn Harrison, these are great names for the day. Peachy, Quinn, and Greek. Peachy Quinn Harrison was the smaller of the two, and he borrowed a knife from a friend of his because he was concerned that Greek was actually going to attack him. So he's carrying around a knife with him, and lo and behold, they're in a drugstore in Pleasant Plains, and Greek's brother is already there, and sort of just standing in the back. We don't know if it was premeditated or not. But Greek comes in, and Peachy is there at the counter with the proprietor reading a newspaper or something, and Greek walks up to him, and an argument ensues, and a fight comes out. Greek's brother John comes over, joins in the incident. Peachy pulls out his knife that he had brought for self-defense and ends up stabbing Greek. Greek dies three days later. John Crafton is injured, becomes one of the key witnesses against Peachy in the trial. And as it turns out, Greek Crafton had worked as an intern in Lincoln's law office. So Lincoln knew Greek Crafton. He also knew Peachy Quinn Harrison. He knew the family. And the family had asked him to join the defense team. And I would say, with a lot to lose in a case in September of 1859, Lincoln took the case, and the claim was it was self-defense. And there were a number of witnesses called. There were a lot of eyewitnesses to what had occurred. But the star witness was a relative of someone who came up to me here, the great-grandfather, great-great-great-grandfather, I guess, Peter Cartwright, who was probably the best-known preacher in the country at the time and one of the best-known people in the country at the time. And as it turns out, he was the grandfather of Peachy Quinn Harrison. He was also the person who Greek Crafton's family had asked to counsel him before he died. And so he's on his deathbed, and Peter Cartwright claims that he says, "I forgive Peachy. I brought this upon myself." So that, obviously, and I'll talk about that in a minute, that phrase becomes a critical issue in the trial. But this was a case of self-defense, where Peachy was claiming that he had no choice but to do it. And Lincoln ended up examining many of the witnesses, and you really get a feel for Lincoln the lawyer as you read his words, not in a speech, not in a debate, but as a lawyer. And when I'm asked about, why this is the only transcript of a Lincoln trial, the answer is sort of self-evident, which is people just weren't transcribing trials back then very often. So happened the family had money, and Lincoln had recommended that they transcribe it in the event of the need for an appeal, the exact reason we have transcriptions today of a trial. And yet the law was, as has been mentioned, so different back then. And I think that one of the interesting things that we do in the book is sort of talk about getting to the point of this trial for Lincoln the lawyer. I'm often asked about how different courtrooms were back then, and they were far less formal than they are, particularly, as you get later and later in time, in the 1800s, particularly the early 1900s, they become more formalized. But they were less formal. Spittoons were a necessary feature in courtrooms. It was an honorable trade that someone studied for, but the only requirement to practice law was a certificate by a court that the applicant was a man of good moral character. The Circuit Court of Sangamon County certified Lincoln as a person of good moral character on March 1st, 1837. And as many of you know, life on the legal circuit for Lincoln and the others who traveled with him was not easy. Horseback, buggies, muddy roads, bad weather, bitterly cold. They rode through storms and droughts. They stayed in inns, boarding houses, farmhouses, sometimes sleeping 2 or 3 in a bed, 20 men to a room sometimes, eating poor food, the hours long, the pay surprisingly not very good. And as you can imagine, the beds were too short for Lincoln. And he loved it. He loved traveling on the circuit. And one of the things that I think helped prepare a lawyer like Lincoln for a difficult trial like this one was the fact that on the circuit, lawyers didn't have much time to prepare. You really had to be ready to, as we talked about, speak extemporaneously. They had to try cases without knowing all the facts, forced to put witnesses on the stand before uncovering what their testimony might be. And as was discussed, it is true, Lincoln and his colleagues were literally often making up the law, establishing precedents that future courts would come to rely on. 1839, for example, a farmer was accused of stealing a pig. He countersued his accuser for slander, helped reinforce the concept that truth would be a complete defense against such claims. Lincoln, so many of you know, did a whole range of cases. He defended men, occasionally women, accused of illegal gambling, various forms of larceny and swindling, mail theft, running a house of ill repute, forgery, an entire family charged with assaulting a dinner guest, rape, attempted murder. There was an extraordinary array of cases that Lincoln was involved in, but probably my favorite case that Lincoln was involved in was the 1841 Archibald Fisher case. And this is a case about a guy who had disappeared after being seen in the company of the 3 Traylor brothers. It was rumored that Archibald Fisher was carrying a bag of gold coins. About a week later, postmaster received an anonymous letter claiming that Fisher had willed William Traylor, one of the 3 brothers, all of his money, about $1,500. The letter was made public. It aroused great anger among Springfield's, at that time, about 3,500 citizens or so. A thorough search was made of all the places, every basement and pit. Fisher was not found, nor was his body. Henry Traylor was taken into custody, and after 3 days of relentless questioning, admitted that his 2 brothers, Archibald and William, had killed the old man, dumped his body in a pond, told the story in considerable detail. 2 brothers were arrested and charged with murder. Abraham Lincoln took on the defense, and the prosecution presented what appeared to be an airtight case. In addition to Henry Traylor's confession, a woman testified she had seen Fisher and the Traylor brothers enter the north part of town. Other witnesses swore they had found evidence of a struggle in the thicket and that the brothers had been seen spending the gold coins. The circumstantial evidence was overwhelming. All that was missing was Fisher's body. And then Lincoln, for the defense, explained the most serious problem with the prosecutor's theory, that Archibald Fisher was alive. A day later, the enfeebled Archibald Fisher was brought into court, and years later, Lincoln wrote about this strange case, explaining Fisher had wandered away in mental derangement, and then pointed out that if he had died and his body was not found, innocent men would have paid a dear price. He added that several townspeople were greatly upset when Fisher appeared, quoting the drayman Hart, who said, "It was too damn bad to have so much trouble and no hanging after all." Another case of Lincoln's that struck me in particular was a case that Judge David Davis, as many of you know, an old friend of Lincoln's, talked about, where he represented the widow of a Revolutionary War soldier who'd been granted a $400 pension for her husband's service. An agent named Wright withheld $200 of that money. Lincoln and Logan sued on her behalf. The day before his summation, Davis said, quote, "Abe told me to make sure I was in the courtroom because I'm going to skin Wright, the guy who withheld the money, and get that money back." And in his closing remarks, Lincoln said, "Time rolls by. The heroes of '76 have passed away and are encamped on the other shore. The soldier has gone to rest and now crippled, blinded, and broken. His widow comes to you and me, gentlemen of the jury, to right her wrongs. She was not always thus. She was once a beautiful young woman. Her step was as elastic, her face as fair, and her voice as sweet as any that rang in the mountains of old Virginia. But now she is poor and defenseless out here on the prairies of Illinois, many hundreds of miles from the scene of her childhood. She appeals to us who enjoy the privileges achieved for us by the patriots of the Revolution. All I ask is, shall we befriend her?" Davis savored the memory, talking about half the jury in tears, half furious. They awarded the woman every cent that she was due, and more than that, Lincoln paid her way, her home, and her hotel bill when she stayed in Springfield. He refused to accept any fee for her services. And there were other cases. Lincoln was involved in a medical malpractice suit that I was talking to someone outside about. He represented a doctor accused of causing permanent damage by improperly setting carpenter Samuel Fleming's broken legs. In his summation, Lincoln used chicken bones to demonstrate the fact that leg bones from a young chicken were supple and would flex and bend, while the leg bones from an older chicken were brittle and would snap far more easily. This display was said to have had a great influence on the jurors, who were naturally disposed towards their injured neighbor rather than wealthy physicians. And after the jury was unable to reach a verdict, and a settlement was reached out of court, which was viewed as a big win for the defendant. And we're talking about Lincoln as an attorney for some of the railroads. And I love the story about the significant case involving the assessment of taxes against Central Illinois. Lincoln achieves a substantial reduction in the assessment, submits a bill for $2,000 for his services. Central Illinois balks at paying. Lincoln seeks the advice of his colleagues. He sends a new bill for $5,000, which the Central Illinois refuses to pay. He sues the railroad, receives the full amount from the railroad after a trial, and then continued to represent them after that, which I thought was the most interesting part of that story to me. 1855 case, the patent case involving the rights to a mechanical reaper for harvesting attracted national attention. The case was to be tried in Chicago. The defense sought a prominent local lawyer. Lincoln was given a $500 retainer, invited to join the defense team with the promise of a substantial fee if the defense succeeded. Also on the defense team, sort of leading the team, was Pittsburgh lawyer Edwin M. Stanton, of course, to become Lincoln's future Secretary of War. But it was also well known nationally at the time. Lincoln went to great lengths to prepare. He traveled to the factory to become familiar with the operation of the reaper. And just prior to the trial, the case was transferred from Chicago to Cincinnati. But no one told Lincoln. He found out about it, and he showed up in Cincinnati. The lengthy brief that Lincoln had prepared never opened. He was frozen out of all participation in the case. Defense team, even though he was there, didn't invite it to join him in the meals of the team. The judge entertained all the lawyers at a dinner at his home. Lincoln was not invited. He attended the trial effectively as a spectator. When the defense prevailed, Lincoln was sent a check, which he returned, saying he had no right to the fee. The check was sent back to him, which he eventually cashed. But Stanton had said about him at the time, he said, a long, lank creature from Illinois wearing a dirty linen duster for a coat, and the back of which perspiration had splotched wide stains that resembled a map of the continent. And yet, Lincoln, knowing that he had been dissed, let's say, still remarked on the quality of the lawyers he had seen, and he said, I have a lot to learn. He admitted to Herndon, his partner, that he had been roughly handled by that man, Stanton, but obviously held no grudge based on what happened later. Lincoln was a divorce lawyer handling many cases, but one of the most interesting things to me was in his representation of Duff Armstrong, which is probably the most famous case that Lincoln had. And just very quickly, this is the case where Armstrong is out drinking with friends, a fight starts, James Norris smacks James Metzger on the head with a length of wood. Armstrong then hits Metzger in the eye with a homemade weapon, a chunk of metal wrapped in leather called a slungshot. Metzger, more grievously wounded than anyone had suspected, he mounts his horse, tries to ride home, falls off several times. Once home, he takes to his bed and dies 3 days later. And this is the case where Norris, the first defendant, is tried and quickly convicted. Lincoln takes on the defense of Duff Armstrong. And there was the eyewitness to the event, an eyewitness who became a critical witness in both trials. And in the second trial, Lincoln is questioning him, listening to his testimony, starts questioning him about did you see the fight, where were you standing, describe the slungshot, what time did it take place, et cetera, et cetera. And of course, he says he was 150 feet away and could see everything in the brightness of the full moon. And this is when Lincoln famously produces the almanac, turns to the proper page, has him read the description aloud. There was no full moon that night. There was actually a little more than a quarter moon. But one of the most interesting things to me about this case is that wasn't the only reason, and maybe not even the main reason, that Lincoln got an acquittal in that case. After several people testified to seeing Metzger fall from his horse, a doctor admitted that such a fall could account for the fatal injury. It also could have been caused by Norris's blow. Lincoln then produced a witness who claimed he'd made the slungshot and described it in great detail. Lincoln then cut open the leather sack to show the jurors the weapon was this tiny little slug of metal, hardly capable of inflicting the fatal blow. And then in summation, after presenting a case, he made an emotional appeal to the jury that would never be permitted today. But he said, he described himself. He said, he had been a poor, friendless boy, and Armstrong's father had taken him into his house, fed and clothed him, gave him a home. And when the jury went to deliberate, of course, put his arm around Hannah Armstrong's shoulders, escorted her outside, telling her they'll clear him before dark. After only an hour, the jury acquitted Duff Armstrong. But I thought that the fact that it went well beyond the almanac was very interesting. I'm almost out of time, but I want to just conclude by talking about another book that I'm writing now. It'll be out in May, about Theodore Roosevelt. And it's a book where we've got another transcript of a trial. And this one is where Theodore Roosevelt was the defendant for 8 days in a libel trial in 1915, where he'd accused a leading Republican of being corrupt. And the guy sued him. And Theodore Roosevelt, ex-president, took the stand for 8 days. Franklin Roosevelt testified in his defense. But one of the things that's so interesting to me is the connection to Lincoln. Theodore Roosevelt was a huge admirer of Abraham Lincoln. Hay, who was, as you know, one of Lincoln's secretaries, was his Secretary of State. And actually, when he was inaugurated in 1905, wore a ring that Hay had given him with a hair of Lincoln's in it. And Robert Hitt, the scribe, the transcriber from our trial in 1859, not only went on to a prestigious and prominent career as chair of the Foreign Relations Committee in the House, but he was Theodore Roosevelt's #1 choice to be vice president in 1904, and almost got it. In the end, the party bosses who Roosevelt came to despise convinced him to select Charles Fairbanks. But what a connection that was. And the biggest fight between Roosevelt and Barnes, the plaintiff in the case, before the trial was at a Lincoln event like this one. It was a celebration of Lincoln's birthday. And Teddy Roosevelt was going to be speaking. And he and Barnes start chatting, and Barnes's grandfather had been Thurlow Weed. And so Barnes had a letter from Thurlow Weed that had been written by Lincoln. And according to Barnes, Roosevelt asks to see it. And then Barnes says he takes the letter, shows it to members of the press as if it's his own, and doesn't return it immediately. And it became this sort of hilarious moment in the trial where effectively Barnes is accusing Roosevelt of swiping his Lincoln Thurlow Weed letter. The final connection, to me, and probably the most fascinating one, is a picture that was discovered in the 1940s of the Lincoln procession in New York in 1865 of his body. And there was a home that turns out to have been the home of Theodore Roosevelt's grandfather in New York as it passed by. If you look very closely, second floor, you can see two little boys looking out the window. And according to Edith Roosevelt, who was also Theodore's childhood friend, she was there. And that was Teddy Roosevelt watching the Lincoln funeral as a young boy. And so, you know, all of these connections together have always fascinated me. I will conclude by saying that we went today to the Lincoln Museum and to the Lincoln home, and it was very meaningful to me to be here. It was very moving. You know, all of you who've been involved in supporting those organizations as well have done a terrific job of bringing Lincoln to life and maintaining his memory. And you know, I'll just say that, you know, it's not an easy trip from New York for someone like myself. And I will tell you that it was incredibly worthwhile to be here. And so thank you for having me, and thank you for inviting me. I appreciate it.
Thank you very much, Dan. It was inspirational. Thank you.